Are we on schedule for time?
Lord, I'm getting slightly nervous about it, but I gave an estimate of up to 3.5 hours for my submissions, as the Lordship may know. I hope to keep within that, which would take me to 3:30 or thereabouts. I understand the court rises at 4. I'm not certain about that. Mr. King gave an estimate, I think, of up to 2 hours, and I think my only friend for the Industry Party, 1 hour plus or minus, I think. So I think we're okay. I'm conscious.
We're not sitting tomorrow morning, you know that?
I do know that, my Lord, yes.
So there are a total of 6 hours available for the entire hearing?
Yes. Well, my Lord, I think...
Right, well, we'll carry on then. Thanks.
Well, if Your Lordship, if it's thought that I'm going too fast...
No, I don't think there's any concern about that.
There is no worry at all on that score, Mr. Lockhart. We are rather concerned for your opponents that they should have.
Yeah, indeed. But Lord, just two matters before I resume. My Lord Vance referred to the City of Bradford case, which was referred to by Lord Justice Staunton. Lord, we do have multiple copies in court. I have reviewed it very briefly. I don't think it would consist of anything like as much as the case is already in the authorities. If Your Lordship would like it, we have it. Otherwise, I don't.
It can be handed round, and we needn't take more time with it.
Certainly, well, we'll deposit it. And Lord, the second matter arose really from my Lord Home, and it's a piece of paper on Your Lordship's desk. My Lord was asking me about the proposal map, that's the inset map, and we thought, my Lord, it might be helpful for you to see the chapter and verse.
Thank you very much.
Two policies, CC10,
Yes.
related to the Chapel Ash area, which effectively is Raglan Street, and then CC11, the Oil All Saints area, Royal Hospital, and the key proposal set out on the front hand side, first of all.
Thank you.
Thank you. Say more about it.
Thank you.
Lord, I was just about to do the submissions I was making on financial viability in the compulsory purchase context, and I was just about to go to the judgment of Lord Justice Sullivan, which is tab 2 in the appendix, and within tab 2 at page 14. Can I just go back to page 13 very briefly to give it context? At paragraph 33, in the middle of page 13, Lord Justice Sullivan is giving his reasons why what he calls reading across line 5, I think, from the planning cases into section 226 was not appropriate. I'll touch briefly on the first and second of those first and third of those. The secondly, in paragraph 34, bottom of page 13, is this matter of financial viability. Lord, in the interest of time, I won't read paragraph 34, in which, over the page, at the top of page 14, Lord Justice Sullivan refers to the circular in much the way I have, and says in the first complete sentence on page 14, the circular makes it clear that the financial viability of the proposed redevelopment scheme is a highly material factor. We don't dissent from anything there. Likewise, we dissent from nothing in paragraph 35. Paragraph 36, however, against this legislative and policy background, it would be surprising if the potential financial implications of redeveloping the CPO site, including the possibility of cross-subsidy as a result of facilitating its redevelopment, were immaterial for the purposes of any consideration of the extent to which the carrying out of the redevelopment will be likely to contribute to wider well-being benefits. And there, my Lord, we part company respectfully with Lord Justice Sullivan. That is respectfully a leap, both from the terms of the section and, for what it's worth, the terms of the advice, which is not, in our submission, a justified one. Well, those are my submissions on a section devoted to financial viability in the planning and the compulsory purchase contexts. Could I now touch on three matters of factual or contextual background, the first of which relates to the precise circumstances pertaining at Royal Hospital, RHS, as related or otherwise to the development at RSS, the CPO site. And, my Lord, there are three stages in this, and I only make these points so that the court is clear as to the factual background at these various stages, not to make any point of merit about it. There are three stages. First, the position prior to the Cabinet report and decision. Secondly, the circumstances of incorporated within the Cabinet resolution. And thirdly, now. So far as the first two of those, rather than go to the source documents, in the interest of time, I think it is adequate to go to the judgment of the Court of Appeal at tab 2 of the appendix. And as we said in our case, we haven't recited, obviously, all the background facts, and we have referred and asked to be incorporated the relatively full extracts from the factual background given by Lord Justice Sullivan. Can I go to page 7, paragraph 13? And there, His Lordship refers to an extract in the report at paragraph 620, and to the effect the development of the RHS in accordance with the Council's aspirations is unlikely to take place for the foreseeable future unless Tesco's current proposals, which do meet those aspirations, are brought forward through a cross-subsidy from the development of the Raglan Street site. And then he says correctly that the report continues in the following paragraph, and in rather unfortunate word processing format, these are set out under A to D, which is most of paragraph 621. The important one for the court's point is D. They, that's Tesco, will agree to a planning obligation prohibiting the occupation of the Raglan Street store until the works to the listed buildings are completed to the reasonable satisfaction of the Council, subject to the Council making a CPO for the site to support the Tesco scheme and using its reasonable endeavours to secure its confirmation. My Lord, that, if I had to pick a single sentence, as it were, that is the most relevant sentence incorporating the then factual nexus, if I can put it that way, anticipated between RSS and RHS. And pausing there, if one goes to the terms of the resolution.
Just before we leave that, the Tesco scheme means what exactly? Are you saying that refers back to what's happening at RHS, or is it the Tesco scheme for the RSS?
In the penultimate line, my Lord, that is to support the Tesco scheme for the RSS.
Yeah, thank you.
And my Lord, if one goes to the resolution, which I'll come back to in another context later, but if we go to the resolution at the appendix tab 20, I take it from the terms of a letter that was sent rather than the minutes, but this cuts straight to the point. At page 277, was a letter recording the terms of the resolution, which was in terms of the recommendation indeed. The Council has therefore, 1, approved the principle of a CPO to facilitate the carrying out of A, that's Raglan Street, B, that's the development of the RHS, and my purpose in referring to this is over the page. Subject to Tesco producing...
Isn't it significant, the way it's put? The making of the CPO is to facilitate the carrying out of A, the Raglan site development, and B, the Royal Hospital site development.
It certainly is, and I'm getting comfortable. Well, it is privacy. It is the expression in the resolution of what this case is about. But it is totally right. Just on the less interesting point,
The one you're on at the moment, yes.
if I can just carry on with that. It is over the page, subject to Tesco producing further satisfactory evidence of the commitment to carrying out the development referred to as B, that's RHS, before consideration is given to a resolution to authorise the making of the CPO, and then 2, authorise officers to continue negotiations with the view to Tesco and the Council, entering into A, a deed of indemnity, I'm not concerned with the terms, B, an agreement to vary the agreement for sale with the Council dated the 3rd November to provide for additional obligations on the part of the developer designed to secure the carrying out of the development referred to at A and B. And if my lady will forgive me, just staying with the rather more intricate point I'm concerned with before coming back to the headline point that my lady has highlighted. That is a reflection of page 7 of tab 2 that I started this little exercise on, subparagraph D, which I've highlighted from the report as extracted by Lord Justice Sullivan. So, my Lords, that is the, in one brief extract, that founds...
This agreement would be under what, section 106, is that? Tesco and the Council are to enter into an agreement which will secure the carrying out of the development at B.
Well, my Lord, at the time, and indeed up to the Court of Appeal, there was going to be a Section 106 agreement. It is now, and I'll come to it in a moment, an agreement for the grant of a lease of lands which either are or will become vested in the Respondent Council and be granted on a lease to the developer, Tesco. So that's how it's now envisaged.
So it's a term of the lease of the Raglan Street site there.
My Lord, that's right, and I'm going to come very briefly to the document in a moment. Now, my Lord, what happened was that the eve of the hearing in the Court of Appeal, we received a letter from Tesco's solicitors, no, the Council solicitors, forgive me, telling us that the previous agreement of 2005 had been rescinded and replaced by a new agreement of that date, namely the 22nd of July 2009. We weren't furnished with a copy at that stage, and so we, for our part, simply took it on trust without perhaps investigating it, but it was the eve. We took it on trust that there was such an agreement, which indeed there is. But that did not feature at all before the Court of Appeal. The document wasn't before the Court of Appeal, so nobody on our side of the court knew anything about it. Well, what has subsequently transpired is in the appendix tab 15, tab 14, now perhaps I ought to go there first. Tab 14 is the agreement that's referred to in the report that Lord Justice Sullivan has, by reference, referred to. That's the previous agreement which was in place at the time of the Cabinet decision. I can take the court to the details of this if necessary, but I don't think time really properly permits. The present state of affairs is in tab 15. And my Lord, may I preface my very brief remarks on this with this point. In referring to this, I'm not seeking, as it were, to play before the court a different merits argument. This is ex post facto to the decision, and the court is reviewing the decision on the basis of the factual material at that time, of course. However, in the court's recital of the facts, it is not the case that the circumstances before Lord Justice Sullivan pertain today. And the circumstances today are, I can deal with it, I hope, very briefly, are these. There are, at page 151, conditions precedent, as defined here, which we'll see in a moment, are conditions precedent to the grant of the lease. The only one of any relevance is in the fourth line, part 4, phase 1, works condition. Page 153, internal page 5, sets out further definitions which are relevant. Halfway down, phase 1 works means the demolition, preservation and restoration works of the hospital site as set out in the schedule annexed to Annexure 8. While we're on the point, can I go to Annexure 8, which is at page 216. Well, this is headed Schedule of Demolitions and Repairs to be undertaken by Tesco at the Royal Hospital site, July 2009. But what I won't go over the court reading these in the time available, they are effectively, and have been summarised indeed by the council in that case, wind and watertight works. Demolition of what needs to be demolished, perhaps it's unsafe, putting security in the windows to stop ingress of rain, ingress through the roof, and so forth, and carrying out research into rotting timber. Wind and watertight works is a fair summary. Going back to page 153, phase 2 works means the restoration works of the Royal Hospital building. That is the listed building on the site, and these are defined by reference to a listed building themselves. They are plainly intended to be more than the nature of what is said. Restoration works, these are more substantial works envisaged here. Phase 3 works, the next definition, is effectively the development of the rest of the site beyond the listed building. Paraphrase there. Summary. Page 154, I think one last definition, halfway down, the RHS development agreement means the development agreement to be entered into by the buyer, that's Tesco, with the primary care trust, PCT, or such alternative use of the building, that's the listed building, as the buyer shall identify for carrying out the those works at that building at its disposal. But all the page 157, the main principal property clause is clause 7.1. Agreement to lease, subject to the discharge of the condition precedent, the seller will grant and the buyer will accept the lease of the property in the form of the lease agreement. So there we have the phase 1 works condition incorporated. And at page 160, the phase 1 work condition is set out in more detail. Court will recollect its Annexure 8, Annex 8, and clause 19.2, the buyer shall complete the phase 1 works as soon as reasonably practicable I believe, I may be wrong, actually these winter water tank works were carried out by Tesco some time ago, as certainly they should have been, as the owner of the listed building. But in any event, if they complied with this duty, that was to be satisfied by the 22nd of January of this year, last week. That is the only nexus between sorry. Can I then go to page 172? Schedule 2 sets out more details in relation to the Royal Hospital building works. Very briefly, the steps in this are as to phase 2 works, which is the restoration of the listed building. In clauses 1.1 to 1.3, there are obligations to enter into such an agreement, or to endeavour to do so, with the primary care trust. And in 1.3a, buyers shall notify the seller if either finding reasonably endeavour the buyer has not been able to enter into the RHS agreement within 6 months. So that was expired on 22nd of January of this year, and we're advised that it was not possible, or in any event a development agreement was not entered into. 1.4 tells us what will then happen. The buyer and the seller, acting reasonably, will agree a marketing strategy for the building and implement it as soon as possible to endeavour to identify an alternative user. Then there's something about marketing for phase 3 and so forth. So, my Lord, the position is that there is now no obligation on doing anything at the Royal Hospital site linked to anything that takes place at the RSS. As I say, on the merits, I make no point about it. If a point is to be made, and if there is ultimately a compulsory purchase order inquiry, no doubt that's something that Sainsbury will refer to. I simply highlight it so that the court doesn't assume, as I've said, that the facts remain as they were at the time of the Court of Appeal.
But this is a judicial review of the decision of the 30th of January 2008.
Exactly.
So is this then just about costs?
No, it's not about cost at all. It's simply to guard against the possibility of your lordships in their judgments setting out the facts as they were at the time of the Court of Appeal, as if nothing has changed. Well, that's the only purpose in referring to it. There's no cost issue. I don't see to make a very point about that. That's the extent.
But the 30th of January decision 2008 no longer stands.
It's the decision that's up for review.
Yes, yes. But it's of academic interest now, isn't it?
Well, we have been told by letter that the agreement I've just summarised before the call finalises the linkage. That's what we hear. Whether the council will reflect on this, I don't know. I'm emphasising that it doesn't affect the issue before the court, which is to address the circumstances as they were at the cabinet decision.
And we're just here on a narrow point of law, yes or no, is it a material consideration?
On the basis.
And in fact, as I understand it, your argument owes nothing whatever to the fact that you own 86% of this land. If you owned 99% or 1%, the same point of law arises for our determination. Although come any subsequent CPO proceedings, who knows what considerations you might invoke at that point. Yeah.
Well, the second contextual point was the terms of the report and the resolution, and whether one goes to, going back to 20, I hope it's acceptable to extract the resolution from a letter rather than we have obviously the minutes in the papers.
I mean, was the point, Lady Hale-Cook here, the formal issue as identified by
It relates to the formal
the formal issue, which in the event nobody thought anything was going to turn on.
But there is the decision under review to facilitate the carrying out of A, perfectly lawful, B, demonstrably in our submission, unlawful. I just bring that to the court's attention for this reason, that in the decision of the court, and perhaps I shouldn't feel it necessary to go there, but tab 4 of the appendix page 34 of Mr. Justice Elias, who was decision. There is my Lord Brown, is rightly referred at the bottom of the formal issue, and I won't read that, I think in the interest of speed, although there's reference to implicitly treating the RHS wellbeing benefits as related to the RSS. In terms of the resolution, when read in the context of the report, suggests the Council is under the impression that one of the purposes for which they would exercise the power to facilitate RSS. Correct. And then the point about, more a procedural point about caution or otherwise, at the top of page 35, the Lordship addresses that point, and 43 agrees with Mr. Krakowski that the resolution does not read the rules, and perhaps serendipitously, it does not state in terms of the purpose is to promote both developments, even if that is the Council's understanding. It simply says that the CPO will facilitate the carry out of both developments as a matter of fact. That is correct. We respectfully do not accept that way of putting it. It's not merely felicitous or serendipitous. It was the purpose, one of the purposes, of the resolution itself. And one can see that expressed through the eyes of Lord Justice Sullivan.
Well, it says to facilitate, doesn't it? I mean, it's not a question of what he says, it's a question of what it reads.
Or perhaps I left him to go any further. I would just yes, another way of putting it, I hope I'm not falling, as it were, through an open door on this, but another way of putting it is in the judgment of Lord Justice Sullivan, appendix tab 2, page 10. Paragraph 19. The resolution is a response to the report which is referred to in the minutes, and it is clear that in substance the Defendant's Cabinet accepted the conclusion in the report that a CPO should be made to facilitate the interested parties' redevelopment scheme for the RSS because that scheme would, by reason of cross-subsidy, enable the redevelopment of the RSS. It's another way of putting it, and we say that that is the illegality at heart here. Lord, the last factual or contextual point I just want to touch on, and perhaps I can do it very briefly. Mr. Justice Elias approached issue 2 or ground 2 in tab 4. Page 33, paragraphs 36 to 40, I'm not going to read them. It will be seen that he approached this on the basis of a choice, choosing between two developments, effectively. Choosing between two rival submissions by the two potential developers, but was dealt with in the report on the basis that is stated clearly, and I'm sure I don't need to refer to it. This is a decision, in principle, made under the terms of the section 226. It is a decision to make a particular compulsory purchase order. That is self-evidently the case, and page 281, the purpose of the report, the first paragraph, to recommend to members a decision in principle concerning the making of a compulsory purchase order on land at Raglan Street, and the whole of the report and the resolution are cast in terms of, quite explicitly, the terms of section 226. Lord Justice Sullivan, in his judgment, the operative parts of which are from paragraph 22 to the end, says not a word about competition or choice, and rightly in our submission deals wholly with the real issue, that is to say, the scope of the section 226 powers. Lord, my last topic is to deal with certain points in the cases and to respond to the essential points that are raised by many friends. I deal first with issue 1 as it's defined in the facts and issues. And the first point I make, and I will do it very briefly because I've effectively made the point already, as a matter of obvious construction of the section, subsection 1, capital A, the well-being benefits are to flow from the development, being the development to take place on the CPO site. As I have already indicated, those matters would flow not from merely the bricks and mortar, not merely the occupation and use of the development, but I referred also to compliance with conditions or other obligations that relate to the development in the sense that I made submissions on this morning. I stress that because there is one word in our case, I dare say there's many more than just one, but there's one word in our case that we're not, on reflection, happy with. And could I turn to page 20 of our case, paragraph 41, third sentence, the effect of section 1 capital A is to require consideration of the well-being benefits of the physical development of the site to be acquired, which may in some cases be experienced off-site, but not to have regard to benefits that might flow from the development of another unrelated site. Lord, on reflection, could I delete of before the physical and put resulting from, which I think is a more happy expression?
Resulting from instead of of.
I would prefer that, my Lord, because it's more apt to import the related conditions and obligations of the...
So employment of people there, that's resulting from.
Oh, my Lord, definitely, yes.
Right, no, I see what you're getting at.
Yeah.
The enrichment of the developers, which results from the physical development of the site, the enrichment of the developers, which therefore enables them to do the RHS site, that's a bridge too far.
My Lord, yes, what takes place at the RSS is not related to the carrying out of the development on the subject site. It is simply by way of a contractual arrangement. I follow that.
I'm just trying to see, I mean, the enrichment of the cashiers, which means they spend their money in other shops in the area, that's all right? And is that something you could take account of?
Oh, yes, it's taking place on the development.
No, they're enriched on the development, but they're shopping,
Absolutely,
they're shopping along the street
absolutely.
and using the local buses.
I mean, is the test really benefits that a reasonable person could objectively anticipate as flowing from the development? You don't need special knowledge about a contract. You can say to yourself, this development is likely to spin off
Yes, I think
all these developments,
what bears
all these
were
benefits.
the two concepts I've endeavoured to get across. Lord, it's what happens on the site in its
yes,
developed and
yes,
used state, employment of the cashiers and so forth, setting a wide range of provisions for the benefit of the shoppers of Wolverhampton and so forth. And it extends to those matters related to the development, such as a necessary. I gave the Plymouth examples of the car park in that case, or matters necessitated and related to the development being carried out on the site. What bears those concepts in mind? Well, that's what I'm focusing.
What it omits here is well-being benefits must be in the area. You say they may be experienced off-site, but they've got to be in the area. And no one, the benefits here are to Tesco's balance sheet, wherever Tesco's finances are. They might be in this country, they might be abroad for all I know, but anyway, they're somewhere. The fact that they then choose to apply that balance sheet benefit to mitigate a loss at another site in the area is, well, quite a remote connection.
Well, Lord, that's right. I mean, we've never really put it in those stark terms of benefit to Tesco's balance sheet. We have always accepted, and accept in terms in our case and in the facts, that the site to which they've sought to bring in here, its development would have well-being benefits. And we've anticipated, the later agreement may cast some shadow over that, but we've anticipated that would be linked, as the Court of Appeal assumed it would be. But, my Lord, otherwise, I agree with
The only reason it's linked is that they've chosen contractually to link it.
my Lord, yes.
And you say now that they haven't even done that. They've got a rather general good endeavours.
My Lord, while my Lord's on this, I was going to come to it later, and I'll try and see if I can hold my thoughts in my head. The benefits are to be, under the section, well-being benefits. They're not even just planning benefits, which one might normally deal with in terms of the planning. They're well-being benefits of a very wide scope. These happen in the instant case to arise through the coincidence, happy to Tesco no doubt, of their previous ownership of the RHS and the fact that forms an ambition of the council to have it developed in a particular way. But, my Lord, it wouldn't stop there in principle, and that's why this case, respectfully, I think is so important. It wouldn't stop there. It could be a site anywhere within the authorities' area. It could be, although I don't feel it necessary to rely on extreme arguments, but it could be Lord Justice Staunton's swimming pool.
Of course.
And as his lordship said, it might be the development of a swimming pool in some deprived housing estate, the other side of the city area, or it might be a cheque.
Yes, supposing the local authority had owned the Royal Hospital site and said, you're going to make a huge profit out of this if you'll give us $1 million to enable us to develop this site, would that be in principle different?
My Lord, I don't speak for them, but, my Lord, on my precise understanding of the case consistently put against us, that's a lawful inducement for the exercise of compulsory purchase powers on the CPO side.
I mean, if there are two choices and they're both in planning terms equally good, how do they choose between them?
My Lord,
assume that they each own 50%. I mean, otherwise you might say, well, whoever's got the most should get it. But assume they each own 50%, equal planning merit for the development on site. How do you decide between them?
Well, Lord, they have to decide. I'm sorry, this is
But what you
a
do
lame-
say is you can't top one side up with an offer.
No, you can't top one side up with a cheque for the swimming pool or whatever it is. You've got to address your mind to the circumstances of the site, its development, its viability, and you've got to form a view where you have, as in this case, a competition. In most cases, you won't have an antecedent competition quite like we've got in this case. There are many considerations that led to, that are dealt with in what is otherwise a very comprehensive and professional report to the committee of employment and so forth, and they've got to just form a view lawfully.
Which is the more beneficial overall, having regard to legitimate benefits and not illegitimate benefits.
Well, Lord, yes.
So you could have a bidding war on the amount of affordable housing or something like that on the site.
Absolutely so. Absolutely so. Absolutely so. And my Lord, when you read the report, there are differences between the two developments, the nature of the two developments. For example, the development plan, which now lies on your table, requires non-food retailing to take place on the site. Sainsbury's proposed non-food retailing as well as a food store, because they believe they had to comply with the policy. Tesco took a different view. They don't propose any retail warehouse units. They're going to sell some non-food goods from the main store, but that was seen by the council as a disadvantage for Tesco and an advantage for Sainsbury. There were other matters. Tesco produced a little bit more employment and so forth. So there inevitably will be differences, and they've got to be assessed by the author of the report and assessed by the council.
Thank you.
Well, Lord, the submission of my friends appears to be, and I've submitted this below and just touch on it again here, that one is not limited to the development in subsection 1, capital A. One can add on the contract, as it were, the extraneous matter, and that is to wish, in our view, that section 1, capital A, was written in a different form. And may I circulate a very brief quarter-page document which I circulated in the Court of Appeal, which I think makes the point, if I can do that very briefly. Lord, it has seemed to us and seems to us that these are the sort of expression of the powers that Maloney Friends would really need in order to make the submissions that they do. And considering the exercise of their power under little a, the authority, I think, shall is better than may, shall have regard to well-being resulting from the exercise of that power. Now, some phraseology like that might probably would render the circumstances promoted here as lawful, but of course that is not what the section provides. My Lord, then just a few more points to respond. Some of them I've picked up already, so I can take them as read now. Turning to issue 2, as it's put in our cases, and the agreed facts and issues. Issue 2, of course, is, well, irrespective of the construction and effect of 1 capital A, can these well-being matters nonetheless form part of the authority's decision? This was, of course, the basis on which the learned judge at the High Court decided the case against us, having found for us on 1A, then found against us on this, as it were, broader power. And I simply make and emphasise, and I think I need do little, if anything, more than refer to our case for one moment at page 15. It's paragraph 29, my lords. If I can just summarise it this way, what we mean in paragraph 29 is that Parliament has decided and enacted that the well-being concept is brought in through one capital A. These are well-being benefits which must arise from the development being carried out at the subject site. And what we're saying in paragraph 29 is, well, that is where Parliament, that is where and how Parliament has prescribed that these matters are to exercise the decision maker. If that's right, and if we are right on the construction under issue 1 of 1 capital A, that these matters must all flow from the development of the CPO site, then it would be going outside the intention of Parliament to then revisit these considerations through another guise and through another part of the statutory process.
Mr. Lockhart, Maria, somewhere I think I've read that 1 capital A doesn't apply in Scotland.
You have read that, my lord. The Scottish provision, as we've set out in our case, is on all fours with the previous version of section 226.
So it's basically a 1 little a position. I know there are slight.
It's a 1 little a and 2 position, old 2.
Yeah. But I mean, are you suggesting that you could get a different result in Scotland from England as to whether or not it's a deal like this works? It's a simple question, yes or no?
My lord, you couldn't get this deal lawful
in Scotland either?
In Scotland, in my submission. It's quite extraneous to the purpose of the section, which is to secure the carrying out of development and required out for that purpose.
You'd have a direct incorporation of the considerations relevant to planning permission, wouldn't you? Yes.
You would, my lord, and they go to the provisions of the development plan so far as material, or material to the scheme of carrying out. The planning permission for any development on the land, it's not some other land, and any other considerations which would be material for the purposes of determining the application of planning permission on the land. Exactly the same result, in accordance with the highest authority, material circumstances which would be relevant there would relate to the development being carried out and not some other unrelated development.
It's really, will result from the carrying out of the development. That's still an activity. What really you're saying is will result from the change that the development will effect to the site. I was looking at your paragraph 29.
Yes.
Well-being will result from the change that the development will affect to the site.
Yes.
Because you might say, well, actually carrying out the work is going to give employment to a lot of people. But that wouldn't be enough. That wouldn't be...
That would be too easy.
Yes.
Well, the next point, also arising under issue 2 is concerned, is the planning cases, which you know, as you know, have featured prominently in the arguments which reference to those cases and find their way into the judgment of the Court of Appeal. Well, there are 2 points on this. First, what is the effect of those cases? And secondly, what is their relevance here? So as far as the first of those is concerned, I have touched on these through the Plymouth case and the Tesco case. In our case, starting at page 17, and running through with a little visit into Monaghan, page 19, where we have referred to the Plymouth case in paragraph 35 and the Tesco case in paragraph 36. Well, as I've already submitted, in a sentence, the principle is material considerations are or may be taken into account if they relate to the development in paragraph. The example is given. The Tesco example is more tenuous, but nonetheless is found benefit the construction of a road bridge found to relate to the development of offset as an adverse impact. But I'm in your Lordship's hands really, and with an eye on the time, of course. I had not anticipated taking the court through those cases because they are well known and their principles are clear. If the court needs assistance on what those cases say, then
You've really highlighted the bits that matter to you, don't you, in June 37 and 38 and so on. I would have thought we've got enough in your written case without looking at them.
Well, that's why I placed these paragraphs.
Yes, thank you.
And if you wish to see them further, you will find those references.
Yeah.
And can read in particular the judgment of Lord Hoffman, the speech of Lord Hoffman in Tesco, and the speech of Lord Justice Russell, and others in the case, and indeed Lord Justice Hoffman in the case. And you'll find these benefits either making the development on the site more attractive itself or offsetting some impact that is caused by the development. And that's, as we put in our case, the dividing line between what emerges with buying and selling of planning permission, or, as in this case, perhaps Lord, as to the second point I there raised, that's to say, what is their relevance here? Lord, again, in our case, at page 21. Lord, at paragraphs 44 and 45, you'd like to read a piece of you say, 44 and 45, we've endeavoured to emphasise the relevance of the planning cases, such as it is, to merchant purchase work. We are, of course, in the same Act, the 1990 Act. It would be surprising and in principle unsatisfactory if what was material for grant planning permission, which is at some stage a necessary ingredient of the CPO scheme, has different consequences to those compulsory purchase plans, or vice versa. One would look to conformity. That's particularly the case, we suggest, in the context of the draconian powers, as they can be, of compulsory purchase. Of course, there are differences. Indeed, I've sought to emphasise the differences in my friend's case is open to decision of the House of Lords as it was in the standard commercial case, which my Lord will recall being engaged on it. It's tab 29.
Just before we go, just going back to the previous point, the possible relevance of the planning permission approach. Is it right to say that here you might look at the fact that the compulsory purchase order is being made in order to promote a particular planning application, and if a factor isn't relevant to the grant of planning permission for the Tesco scheme, then one might ask, why is it relevant to the making of a compulsory purchase order, the whole purpose of which is to promote the Tesco scheme?
Why isn't it relevant?
Why is it relevant, you might ask? Yeah, I mean, is that the sort of nature of your consistency argument?
Well, my Lord, I would say it is relevant. I mean, one notes that in the old section, now, the grant of planning permission is a specific matter.
Yes, no, I wasn't. I was trying to put that point. If it's not permissible in one context, why should it be permissible in the later context when the compulsory purchase order is being made effectively to give effect to them?
Exactly. Well, that's right for being said. Absolutely. And I would say all the more so when you're not dealing with the grant of benefit under Section 7. Section 7 just gives you a benefit. You can take out that benefit or not. It doesn't do anybody any.
You're actually expropriating somebody else.
Now we're taking someone else.
Yes.
And I'm sure you've got consistency in that sense. In that regard.
Sorry, I interrupted you.
I mean, I'm just wondering, I mean, I absolutely see the force of that, and certainly it's a point that struck me, but I mean, could it be said against that? I just wonder, ex hypothesi in a case like this, both the rival prospective developers have got their planning permissions. I know that theoretically here, or in fact here, somebody hasn't who it.
Issued to Tesco.
But you haven't got it. But I mean, in principle, you're so there isn't any question of, so to speak, getting an authority to develop, a permission to develop that you shouldn't get by bribery. It's at this stage a question as to who should, so to speak, get the benefit of it, who should be actually allowed to do that which is regarded as intrinsically appropriate and acceptable development. And therefore, if you can throw something else into the balance, why shouldn't you? I mean, that's the argument, I think.
Yes, but I hope that the answer to that is this. The general test of the grant of a planning permission, and I think this is put in one of my friend's cases, the general test is, does it regard with the development plan? And is it, for that reason or otherwise, objectionable? Yeah. You don't grant planning permission because it must be a good thing. You grant planning permission because it's acceptable.
Yes.
I use the word appropriate, but acceptable. The test for compulsory purchase orders is quite different. Not merely acceptable. It is. Is the carrying out of that scheme justified in the public interest? Yeah. Certainly said, is there a compelling case in the public interest to carry it out? And that adds a whole new dimension to considerations which go beyond mere acceptability. What is in the public interest, such as to deprive the owner?
You were going to refer to standard commercial. What particular point are you taking?
It's raised against us, and kind of, as your Lordship will recollect, it's a very complicated case. And I wasn't proposing to go to the speeches at all. May I just deal with it in a few?
Yes, of course.
What it points to? Firstly, that is not in the case.
Not a what?
Not a case in which compulsory purchase powers are being distributed. It's not a case on compulsory purchase. It's about disposal of land under the relevant section. Second, the background to the disposal and issue was section 189 of the Scottish Act, which I haven't really made this point, which equates to old section 226 in England, no well-being. If I may abbreviate it that way. Or thirdly, it is a case on the Scottish powers of disposal of land, specifically on the meaning and effect of the phrase best terms, the language of the relevant section being different to the section in England, which is section 233.
233.
233.
Yep.
Fourthly, and I just make one visit into the decision, which is the authority bundle 2, paragraph 29. Whilst for the reasons I've given, the case is of no assistance, no relevance to the task in this appeal. At page 649, internal page 17, in the speech which commences at
Afraid it starts pretty well at the beginning. It's page, yes, it's 634.
634, the speech of my Lord Lord Fenn. At page 649, paragraph 39, when His Lordship was addressing the meaning of best terms and its effect there, he said this: the emphasis in this document, that's a planning brief, on the wider benefits that were expected to flow from the redevelopment was taken a step further in another document. And then the details are set out, which really I don't think it would be appropriate to go into here. So, Lord, for what it's worth, and I respectfully, for reasons of the distinction, I don't think this case helps us one bit. His Lordship was, as in this case, focusing on the benefits expected to flow from the redevelopment. And my Lord, I think I have one last point to. It arises, my Lord, from the Tesco, the interested parties' written case. And it's page 1. And going to the essence of it, in paragraph 2, second sentence, if I can pick it up there, if the appeal by Sainsbury's is allowed, the statutory purpose of exercising compulsory purchase powers to improve well-being within that area would be undermined. In the circumstances of this case, the Council would be unable to support the bringing forward of development beyond a compulsorily acquired site, even though it's common ground that such development would have clear additional well-being benefits for the area. And that's reflected in a concluding paragraph at page 21, paragraph 78. Conversely, Sainsbury's approach should be rejected because it would unjustifiably limit the ability of a local authority to act positively in the planning and regeneration of its area, and so forth. And my Lord, I would make this very brief response to that, as it were, in terrorem type of comment, one is being invited to form the impression that really it's only in practice by bolting on this consideration of the RHS to the RSS that one will achieve proper planning. Lord, that is very far from the position. We are, of course, in this case, just addressing the specific powers within the Act of Section 226. They lie...
those powers within the scheme of the Act as a whole. The scheme of the Act as a whole is essentially in these broad compartments. We have the contents sheets of the Act as a whole. But one starts in the Act with development plans, now altered by the 2004 Act called Local Development Documents. Whatever they're called, they set the planning policy for the area. So if a council wants to achieve something on the site, that will be its normal starting point. Policy, perhaps with a development brief or a plan brief. So it's open to the council either to update their plan if they think that plan is inadequate, or to formulate planning brief. There's a very ancient planning brief related to the RSS, but not enough today. Then that feeds through into the development control process. The development plans provide the framework for the grants of planning permission. Indeed, we now have, and it's in section 61 capital A by amendment of the 1990 Act, if an owner is being tardy or unimaginative, the council itself can grant planning permissions for sites by what are called local development orders. So it can be proactive. It can say, yes, we have a problem with viability here, if we have, well, this is the sort of planning permission we're going to grant, and that'll get the site moving. Fourthly, there are listed buildings on the site. They feature prominently in the arguments. There are, of course, powers under the Listed Building Act of 1990 to secure repairs. And lastly, of course, there is compulsory pensions. If all comes to nothing and Tesco, I'm sure they won't, but if they were, or some other owner were simply to close the door for it and not let anybody in, and send it to the council to make a compulsory purchase order. My point in making these very abbreviated submissions is that there are powers available through the proper process for the council to achieve the proper planning of the area. It's lamentably not being achieved for the time being able to do.
Thank you very much. Mr. Cause? Yes, Mr. King.
My lord, my lady, there are 4 facts in this case which we submit as fundamentally important to the lordship's decision. The first thing, the first fact, is that as things stand, if anything is to happen on the Raglan Street site, the Wolverhampton City Council is going to have to exercise its powers of compulsory acquisition under Section 226 to facilitate the development of the site either by Sainsbury's or by Tesco. There is an impasse between those two companies. One stage, as your lordships perhaps would have seen from the papers, Sainsbury's were intending to sell their interest in the site to Tesco, but they changed their mind, and we now have reached a position where if anything's going to happen on this site, the council has got to do something about it. It obviously has the second fact that I would submit as of fundamental importance is that the acquisition of the RSS, the Raglan Street site, to
that's agreed between the parties. It's in the statement of facts and issues.
Could you just repeat that? To meet
Of course, I'm sorry. The acquisition of the RSS
Yes.
by the council to facilitate either scheme,
Yes.
whether it be Tesco or Sainsbury, would meet the test in section 261.
It would be very surprising if that weren't common ground, wouldn't
It
it?
would be surprising, but it is. In fact, I would expect obviously of some significance in terms of background at least. Thirdly, it's agreed that both schemes would bring well-being benefits to the council's area. So it is that it's agreed that the requirements of section 2261 big A would be met whichever way the council decided to exercise its powers. And the fourth thing that is agreed, and which is, I think, of fundamental importance in terms of the facts of the case, is that the proposed development of the Royal Hospital site by Tesco would result in further well-being benefits to the council's area. Now, as your lordships know, obviously, the council's decided to grant planning permission for both schemes, although self-evidently, because they relate to the same site, only one of them can be carried out. As my Lord Brown has just said, I think one planning permission has been granted, the other one is about to be granted. That is, the Tesco permission is in place. The Sainsbury's permission will be issued, as I understand it, quite shortly. So this isn't one of those cases where at the planning permission stage, the council had to choose between the two schemes and decide which one it preferred. It decided both were acceptable and granted planning permission for both. So it's not a Tesco Whitney case, for
I wasn't
example.
quite sure. I picked these up from the agreed statement. Tesco
so
submitted
sorry,
an
I do
application
apologise.
in 2006, April 2006. They have now planning permission.
Planning permission has now been granted for the Tesco development,
Yes.
but it hasn't for the Sainsbury's development. Right. But the Sainsbury's permission is imminent.
Yeah. Thank you.
The council, my lord, some time ago, did resolve to grant planning permission for both, but there have been discussions about affordable housing and all the rest of it, and other obligations under Section 106. Tesco permission issued, Sainsbury's permission about to be issued. There's one relatively minor, as I understand it, outstanding issue on the Sainsbury's permission. At the permission stage, the council did not have to choose between the schemes. It didn't have to decide which it preferred.
Sorry, does it?
Yes.
Does it ordinarily have to decide that at the planning? I mean, why can't it grant both in the ordinary way?
It can and it will. But in some cases, a planning authority, some of the cases that have been decided by the courts were concerned, and Tesco Whitney is one, are concerned with a situation where only one planning permission can be granted. For example, because there's only retail capacity for one of the schemes that's in competition.
I see.
That's the point I was making.
I see.
So it wasn't a competition situation at the planning permission stage, but it is now.
Yeah.
By now, obviously, I mean in the compulsory purchase context. Now, as I understand it, the appellant's argument means that the council would be precluded as a matter of law when it makes that choice in the compulsory purchase context, as it now has to, from taking account of the fact, as I've just mentioned, that is, that the development of the Royal Hospital site, as Tesco propose, will satisfy or meet the objects of section 2261 capital A. That is, it will bring well-being benefits to the council's area. And obviously it's our submission that that cannot and indeed is not right. Cannot be and is not right. Quite obviously, the relationship between Tesco's RSS development and its Royal Hospital site development I mean, that relationship or connection lies at the heart of this case. Reference has been made to the mechanism by which that linkage is to be achieved. That is the conditional agreement for lease dated the 22nd of July last year, 2009. Obviously, it's not been suggested that that isn't in itself lawful. No judicial review has been made of that mechanism. I'd respectfully submit that the nature of the mechanism and whether it's good enough or not, as indeed my learned friend Mr Lockhart-Mummery really said in his submissions, isn't critical. Indeed, it's not really relevant to the issue before your lordships. If a CPO is made in Tesco's favour following your lordship's decision, then as Mr Lockhart-Mummery himself said, it will be open to Sainsbury's as one of their objections to the compulsory purchase order, so to say the mechanism's no good anyway. We would not accept that submission, but it's not, in my respectful submission, directly material to the issue that your lordships have to decide.
Would it be material if there were no sensible mechanism to bring about what the council wishes to achieve? Because clearly there are problems about using a section 106 for this purpose, which is no doubt why you've gone down the private contractual route.
Well, we certainly don't necessarily accept that a 106 couldn't have been used, but it is not being used. But in response to my lady's question, if it could be demonstrated that there was no way that a mechanism could possibly be established which could lawfully create the linkage, for want of a better shorthand, then clearly it would be difficult to suggest that the cross-subsidy proposal really was a matter to which any weight could be attached. But I would respectfully suggest, and this point will appear later in my submissions, that it's a matter of weight for the decision maker and not for the courts. And I'm going to have to look in a little bit more detail, I'm afraid, at one or two of the cases to which Mr Lockhart-Mummery made reference, and I shall do so obviously as speedily as possible. I hope that deals with your ladyship's question sufficiently for the time being, at least.
So the mechanism,
yes.
I'm not sure I've fully grasped what it now amounts to. It amounts to a best endeavours or reasonable endeavours obligation to enter into a development agreement for the RHS, coupled with an option in the council to purchase for some unknown sum in the event that Tesco actually doesn't get round to it by a certain date. Is that a rough summary?
Yes, broadly speaking, my lord, except that there is an additional facet of this, which is that if the option's exercised and the site is transferred to the council for the agreed sum, then Tesco have to make a further payment to the council, a balancing payment to the council upon completion of the transfer of the land. The purpose of the payment, as I understand it, being to fund development on the site.
Where do we find that?
My lord, it's
page 171, is it?
Yes, page 171 in the schedule. One also has to look at some of the definitions.
Yes, I see.
Page 171, as my lordship has obviously already seen.
Paragraph 4, yeah.
And then the balancing payment
Yes.
is defined on page 149. But I must respectfully submit, I mean, obviously I can deal with this in more detail if your lordships wish me to, but I respectfully submit this really hasn't got anything to do with the point before the court. I mean, if the court decides that, yes, this can be taken into account and a CPO is made, then it may be that Sainsbury's will say, as I've said, to the Secretary of State, this is hopeless, this document. It's not worth the paper it's written on. It doesn't create a proper linkage or whatever it is they want to say. We won't accept
Mr Lockhart-Mummery, I think, has made it quite plain
Yes.
that he's not seeking to rely upon this point. He's prepared that we approach it on the basis that there will be a commitment, which is part of the value to your clients of choosing Tesco rather than Sainsbury.
Yes, that is the basis of the resolution, of course. The resolution in principle, the decision hasn't even been made yet to make a compulsory purchase order, but in principle it's been made. But the order cannot be made in the sense of issued in any formal sense until that commitment has been secured. and obviously pending the outcome of your Lordship's consideration of this case. Well, I will, if I may, as it were, move away from that. It's respectfully submit, it's important to appreciate that the basis for the Council's decision in principle to facilitate the Tesco scheme through the making, on the RSS through the making of the compulsory purchase order is that because the RHS scheme is financially unviable, without the proposed cross-subsidy from the proceeds, the profits from Tesco's RSS development, the RHS development is unlikely to take place for the foreseeable future. Those are the words of the report to Cabinet for my Lord's reference. I don't think it's necessary to take your Lordship's there, but it's tab 20 in the core volume or the appendix, page 291, paragraph 6.20. That is the, sorry.
6.20.
6.20.
Thank you.
Now, Sainsbury's, as it were, may or may not agree with that conclusion. Indeed, it's probable that they don't. But again, whether or not they agree with it, I respectfully suggest doesn't have any real bearing on the outcome of these proceedings. But it's another example of the sorts of matters they could raise, and no doubt will raise, if a CPO is made in Tesco's favour and we proceed to inquiry. And the Secretary of State will have to decide, in the light of his inspector's report, whether, but for the cross-subsidy, the RHS development was or was not likely to take place. And in the light of other matters that he or she will have to consider following a CPO inquiry, what weight to give to the RHS wellbeing benefits in deciding whether to confirm the CPO. And we submit, and obviously I'm going to come to the words of the statute very, very shortly, but it's our submission that the wellbeing benefits that will result from, those aren't words used in the statutory provision, but other words are used, which Mr. Lockhart-Mummery perhaps has not given sufficient attention to with respect. We submit that the wellbeing benefits that will result from the development of the RHS as a consequence of the cross-subsidy that the development of the RSS will provide is plainly relevant to the Council's decision whether to make a CPO to facilitate Tesco's RSS development.
Can I just ask, your first point was that there's an impasse, but
That's right.
your case would presumably apply even if Tesco owned 100% of the site, even if Sainsbury's owned 100% of the site, and Tesco, as an outsider, had simply either said it would endorse the Sainsbury's planning permission or had got its own planning scheme without having any interest in the site. Would it be your case then that the Council could say, we're going to compulsory purchase Sainsbury's site because we believe that the benefits of having Tesco develop it when it's going to develop the RHS site at the same time or are overwhelming?
Yes, but the balance of considerations would be different. Again, in my respectful submission, it would be a matter for the Council initially, obviously, because it's the authority that has to make the order, and then for the Secretary of State to consider whether in circumstances where a party owns 100% of a development site and can carry out a development for which it has planning permission on it, can there be a compelling case in the public interest, such as would justify the compulsory acquisition of that 100% interest in order to facilitate a similar development by another superstore developer in order to get the well-being benefits from the RHS. Yes, it would certainly still be relevant, but the balance of considerations would be different, possibly very different.
Could I put a different scenario? Yes. Imagine that the owner of the land isn't interested in any development at all and hasn't got planning permission, but he wants to keep his land. A farmer who's got a field or something. Along comes a potential developer and says, now, I would like to develop this land, please. And the proposal is one that doesn't tick the boxes of itself. A large casino with a lap dancing club. And this is going to make me enormous profits, and I'll put all my profits into redeveloping the hospital. Now, in that situation, could the local authority properly exercise its power of compulsory purchase?
Well, yes, absolutely. But it would be extremely unlikely. It would be extremely unlikely that they would get away with it. That actually is a fundamental part of our submissions, that there is this process through which compulsory purchase orders have to go. That is the confirmation process by the Secretary of State. I mean, your Lordship indeed chooses I understand, a very extreme example. But the question, as I understand it, if I may say so, is really, could the Council in those circumstances still take account of the benefit that would flow from the casino and lap dancing club developer paying for the redevelopment of a derelict listed building in the centre of town? My answer must, of course, be yes, they can take it into account, but in those circumstances, it is most unlikely, and your Lordship obviously would I'm sure, agree with that, it is most unlikely that either an authority would make an order to do such a thing, or that the Secretary of State would confirm it. But why should the court try and, if I may respectfully say so, lay down some sort of dividing line when the Council itself and the Secretary of State must look to see, and the cases, if I may respectfully anticipate what I'm going to say in a moment, the cases support what I'm about to submit, that the relevance of and weight to be given to financial considerations are both a matter for the decision maker.
Well, Mr. King, while we're on the extreme examples, I mean, yes. Then take this case, but assume that there wasn't a Royal Hospital site, and it was simple cash. I mean, Tesco say, well, there's a couple of million for you to spend for the public benefit in this area.
Well, if the cash, if it was simply a sum of money, saying, here, take it and do what you want with it, that would be extremely difficult to justify,
well,
obviously.
I've said to spend it on
if it was going to be spent on specific
area.
I'm so sorry, my Lord, I interrupt.
Yeah. No, I mean, that's why I actually did say money that is to be devoted to the general welfare of this area.
Well, if specific projects, or not necessarily projects, but
a swimming pool.
The widest possible.
I mean, take the swimming pool example.
I will course, surely.
Well, I thought the swimming pool would come up, and I was going to deal with it quite directly in the context of Monaghan. But yes, well, if Sainsbury, if I may say so, Sainsbury's tomorrow or after your Lordship's decision came back and said, I don't know whether there's a need for a swimming pool in Wolverhampton. Let us say that there's a site that's been identified in Wolverhampton for swimming pool development, and Sainsbury's say, well, for the well-being of the area, we'll help you fund that swimming pool. I would say, yes, it's material. Why shouldn't it be? The weight to be given to it is a very different matter.
Well, there's an example. I know it's from north of the border, but it's in my mind where
Yes.
the developer of a wind farm undertook to give a very substantial sum of money each year to the local community council to be paid, to be distributed on projects such as improving playgrounds, swimming pools and so on in the area. And it's not a specific sum of money for a specific piece of development. It's left to the council to decide how to spend the money, but it's a commitment. And that's a quid pro quo, as it were, for getting planning permission. It wasn't a Section 106 agreement, but they've done it.
Perhaps the local residents weren't sufficiently legally informed to challenge this.
Had they known it, I think they would have challenged it. But that is what has happened. And it was under the council.
Well, I'm not sure how that could be secured other than through a 106 obligation, my lord, although obviously there may have
wasn't.
been some other form of agreement. Well, clearly, if a developer offers something that isn't tied down in a legal sense, then normally the approach would be that the decision-making can give little, possibly no weight to it. But just in terms of whether those matters were relevant, of course, if I may respectfully say so, every case will depend on its factual circumstances. In principle, that's a planning commission project.
Yes.
I am going to go on in a moment to submit that the compulsory purchase contract is actually very different, and certainly we would not accept with the greatest possible respect, my Lord Mantis, I think it was, suggestion that if something isn't material to a planning decision, then it follows that it wouldn't be material to a decision on a section 226 compulsory purchase order, because as I shall seek to persuade your lordships in a moment, the 226 power now is something very much more than a planning power.
Could I...
Regeneration power.
Could I just recap on Section 106 agreements, because a number of references have been made to them, but not very fully. And is everyone agreed that you can do more or less anything you like under a Section 106 agreement, so long as it occurs as part of the deal, or under which planning permission is granted? But once the planning permission is in place, you can't then say, let's tack on a 106 agreement to it.
Well, of course, a Section 106 agreement can be entered into after the planning permission is granted, but that wouldn't be normal, because once the developer has his permission, he's unlikely to want to offer sums of money or other.
I see that, that's why I asked, but you say it could nevertheless be done, could it?
It can be done, a Section 106 agreement, or unilateral obligation. Of course, it doesn't have to be an agreement, it can be a unilateral undertaking which contains planning obligation, to be entered into by any landowner at any time, whether it's associated with a planning permission or not. It doesn't normally happen that way. Of course, 106 agreements or undertakings are normally entered into or made at the time planning permission is granted. On the land. But in terms of, we'll have to look at the Tesco case a bit later on, I suspect. But really, as I understand it, the Tesco Whitney position was that more or less you can do more or less anything you want in a Section 106 agreement or undertaking. You've just got to be within the terms of the section. But whether it's then a consideration that's material to the planning decision is another question. That we would need to look at, perhaps. Now, I will, if I may, just turn to the relevant statutory provisions, because one or two things I would like to point out. Every time I move forward, I either switch on or off the mic.
That's your learned junior's main function, is to make sure when you lean forward, he then switches it on.
Well, I've tried, but it's not actually working.
Yes, it is.
Yes, it is. I didn't press it for long enough. My apologies. Now, it's on. Yes, I'm not sure. I'll try not to do it again. If I can invite Lordships to take in hand again the volume 1 of the authorities bundle and turn to tab 1. Obviously, Lordships have seen this already, so I'm going to try and do this fairly quickly. Just on section 226(1)(a.
Little a or big A?
I'm talking about little a. I'm sorry, yes. Little a, starting at the top, as it were, and working down. If the authority think that the acquisition will facilitate the carrying out of development, redevelopment or improvement, just to touch on a point that was raised, I think, by Lady Hale earlier, if my memory serves me, or perhaps other members of court as well. What's meant by improvement, if it's not development? If I can invite attention just very briefly to tab 9, where we find section 55 of the 1990 Act. We've looked at subsection 1, but if we look at subsection 2, for example, 2A, the following operations or uses of land shall not be taken for the purposes of this Act to involve development of the land. first of which is the carrying out the maintenance, improvement or other alteration of any building or works which affect only the interior of the building or don't materially affect the external appearance of the building, I'm sorry. I mean, that obviously, acquisition for an improvement of that kind, even though the word improvement is there used, could fall within 226(1)A when it didn't involve development as defined in subsection 1. Another example might be...
I'm struggling.
Oh, I'm sorry.
Well, only to follow the example through.
Well,
Improving the internal redecoration doesn't sound like a very obvious thing which you would need to compulsory to purchase some other land to.
Yes, what about the examples of the canal, the footpath along the canal and the amenity fields and so on? Aren't they perfectly good examples?
Yes, I hope I'm not suggesting that they're not, but I was just pointing out that there is a provision in the Act which actually uses the word improvement in the context of defining things that don't count as development. That's all I'm trying to do. But my lord, yes. Sure. But can I very briefly deal with this point? And your lordships may say don't bother, because I don't believe it's central at all to the arguments. But Mr. Lockhart-Murray did make some remarks about the words in relation to the land in subsection 1A of section 1 little a of section 226. As he said, we've never relied on that, and we don't rely on it. I just wonder whether his first example can be quite right, because if one's talking about land needed to provide access, which I think was his first example, to a town centre redevelopment scheme, then it seems to me that would almost certainly either come under 1A itself, because it was part of the development that was going to be facilitated, or if it didn't for some reason, then it would come in under 3A, further down page 1 in tab 1, where a local authority exercise their power under subsection 1, they shall have power to acquire compulsory any land adjoining that land which is required for the purpose of executing works for facilitating its development or use. And as I say, I suspect this isn't a key point. In fact, I'm sure it isn't. But I would suggest that an access to a city centre redevelopment scheme would probably come in one of those powers rather than needing to rely on the words in relation to. But anyway, we never have, and we're not relying on it now in this case. Turning to section 226(1) big A, which is at tab 3. Sorry, no, it isn't. It's still at tab 1. Unless, obviously, it says a council thinks that the development, redevelopment or improvement is likely to contribute to the achievement of one or more of the well-being objects, then the section 226(1) little a power cannot be exercised. And there is one of the authorities that your lordships have is Belfields, which we can take, if we may, a very short visit to Belfields, because I don't think there's any issue about this, but tab 13 in volume 1 of the authorities bundle, in other words, in the same volume that your lordships have in front of you, Belfields and Nextdom Bootle Limited, the reference to the case appears on the first page, a decision of Mr. George Bartlett, QC, sitting as a Deputy High Court Judge. Page 227 and... No, sorry, that's not right. 52 and 53. That's bundle page 52 and 53. Paragraph 56. Rather than reading it out, having given the reference, may I just briefly submit that he was right to say, first of all, that section 226(1) big A doesn't contain the power to make a CPO. That's obviously in 1 little a. And there's no issue about that in this case. And he said that 226(1)A big A, that is, imposes a limitation on the exercise of the power. And in broad terms, we certainly don't take issue with that. In fact, in Belfields, the issue of cross-subsidy did arise, although the way in which it was treated by the Inspector and the Secretary of State didn't form any part of the, or any basis for the claimant's challenge to the Secretary of State's decision to confirm the compulsory purchase order. I mean, it is a CPO case, of course. And again, if I can just give your Lordships a reference and probably move on fairly quickly, if your Lordships would kindly turn back to page 41 of the bundle, paragraph 41.
Sorry, R41 or this case?
This case, tab 13.
Yes. Sorry.
Bundle page 41, going over to 42, paragraph 31. I'm sorry, I think I said something different a moment ago.
Yeah.
Paragraph 31. The point there was that, well, if we just look very quickly at the paragraph, there was a further argument on behalf of the two claimants relating to a section in the Inspector's report where he rejected the Council's argument that if individual sites were excluded from the order, this would have consequences for the entire CPO and the redevelopment because government funds might be allocated elsewhere or withdrawn. The Inspector said there was no evidence of that. It could theoretically happen. But then at the top of the next page, at para 414, that is of the Inspector's report, he treated it as of little weight. The Council's argument that omitting individual sites could affect cross-subsidy between development packages and the viability of schemes, and then the Inspector said something else. The site there was quite a large one. We see in paragraph 1 on page 28 of Mr. Bartlett's judgment that it related middle of para 1 to 10.2 hectares of land in Bootle. And I'd simply make the point, if I may, that nobody seems to have suggested that although the Inspector thought it was a poor argument, nobody seems to have suggested that it wasn't relevant for the Inspector to consider the effect of excluding the claimant's plots from the CPO on cross-subsidy between development packages.
Do we take it from paragraph 33 at the bottom of that page that what you've just said is so, that the judge was accepting basically what the Inspector was saying without criticism?
Yes.
Is that right?
Yes. Yes, it is right, my Lord. On that particular point that I've drawn attention to, cross-subsidy between development packages, it doesn't appear from my reading of Mr. Bartlett's judgment that formed a ground of challenge, the way in which the Inspector had dealt with that.
Yes.
It all depends whether you regard it as series of separate developments, perhaps.
Yeah. Perhaps not, my Lord. I will respectfully submit that actually anticipating what I'm going to say later, in my respectful submission, whether or not the two, if it is two developments, one of which is going to cross-subsidise the other, part of the same development package, is certainly in the CPO context of little significance. It's part of the factual matrix rather than a legal test. And certainly it'll be my submission that in Monaghan, none of the judges are to be taken, if I may respectfully say so, as having said that the fact that there was one planning application was a legal prerequisite to finding that it was a material consideration, the cross-subsidy. I mean, they could have been separate planning applications, but weren't. Tesco could have made a single planning application for the development of the RSS and the RHS if they wanted to do so. There's nothing, as far as I'm aware, in statute or otherwise to prevent them from doing so, but they didn't. But may I come on to that a little bit later on in the context of Monaghan. I mean, certainly it appears, if I may say so, from that case, that there was a large site and there was some prospect, at the very least, of some of the development packages within the site cross-subsidising other development packages in another part of the site. I mean, that's as far as one can go. And that was accepted by the parties at least, and by the inspector and by the judge as not being something that appeared to be wrong or illegitimate. And indeed, I would respectfully submit it wouldn't have been. I think, may I just divert to Lord Justice Sullivan's judgment in this case at this point, just to deal with something that the appellants have said, at least in their case, on page 10, paragraph 18.
Page 10 of the judgment.
No, I'm so sorry, this is the appellant's case, page 10, first of all, paragraph 18, and then, if we may, we'll go to Lord Justice Sullivan's judgment. Appellant's case, page 10, para 18, submissions. In the appellant's respectful submission, the reasoning summarised above is fundamentally flawed because it treats the terms of subsection 1 big A as an enlargement rather than as a restriction of the powers under subsection 1A. Obviously, this is related to the is it a limitation point. If your lordships will be good enough to turn on to number tab 2, which is the judgment of the Court of Appeal, Lord Justice Sullivan's judgment, which was agreed with by the other judges. I'd respect this, just that isn't quite what Lord Justice Sullivan said. If your lordships can go to page 11 in tab 2 at paragraph 24 under the heading of subsection 2261A, Lord Justice Sullivan said it's true that 1 big A is negative in form, but in substance, as Mr Lockhart Mummery fairly conceded, it positively requires local authorities, when deciding whether to exercise the power conferred by little 1A, to consider whether the carrying out of redevelopment on the proposed CPO site is likely to contribute to the achievement of the objects of well-being. The statutory language may appear somewhat negative and convoluted, but in my view the underlying policy objective is clear. 1 little a focuses attention on what's proposed to take place on the CPO site itself. And then 1 big A requires the council to look beyond the benefits that will accrue on the CPO site itself and to consider whether, and if so, to what extent its redevelopment is likely to bring economic, social, environmental well-being benefits to a wider area. Although it is in the informal limitation, in practice, the purpose of subsection 1 big A is to broaden the issues that must be taken into account when deciding whether or not to make a 1 little a CPO. And then he also says, again, no convoluted, 1 big A is expressed in deliberately broad terms, likely to contribute to the achievement of the well-being objects. It's not prescriptive as to the manner in which carrying out of redevelopment might make a contribution to such wider benefits. And then he starts to give some examples. But with respect, what Lord Justice Sullivan said in paragraph 24, there's clearly no issue about that between the parties to this appeal. That is negative in form, but it imposes a positive duty or requirement on local authorities to consider well-being benefits. What he actually said, as I've just drawn attention to in paragraphs 25 and 26, is not that 1 big A enlarges the power. It doesn't say that at all. What he says is that it broadens the issues that must be taken into account by a local authority when deciding whether to make a CPO under section 2261 little a. And in our submission, that's a perfectly fair way of looking at it, and it's consistent with what Mr Bartlett said in his decision in Belfields. So with that, can I return back to the section which is in the core volume at tab 1, that is section 226, because in a moment I just need to in the authorities volume, I'm so sorry, in the volume 1 of the authorities, section 226. I just make 1 or 2 further submissions about that. It is, and this point I think has already been picked up actually, but under subsection 1 big A, it's the development, redevelopment or improvement of the law order land, not its carrying out, that the authority must think is likely to result in well-being benefits. It's subsection 1 little a that refers to the carrying out of development. 1a refers to, for want of a better shorthand, the consequences of the development, redevelopment or improvement. And may I also draw attention, as Lord Justice Sullivan did, to the words in 1 big A, likely to contribute to the achievement of any more, one or any more of the following objects. Those words, I would respectfully submit, are very wide. And as a matter of ordinary language, it is our submission that the RSS development is indeed likely to contribute to the achievement of one or more of those objects, amongst other things, by providing a cross-subsidy for the RHS development. As a matter of ordinary language, it falls squarely, we respectfully submit, within that provision.
So you say, I mean, the appellant's right in saying, you say that not only were your people, your council entitled, they were absolutely bound to take account of the further benefits that Tesco were going to bring.
Well, if they hadn't, the subsection 1 big A doesn't say that they have to take every single well-being benefit into account before they make the order. What it says is that they must be satisfied that there is at least some well-being benefit that's going to arise from the development. But if they hadn't taken it into account, then Tesco, we would obviously submit, would perfectly rightly say to us, you haven't taken that into account and you should have done. So I'm not sure I go quite as far as to say they are bound to take it into account, but it is material, and if they don't take it into account and don't promote a CPO in Tesco's favour, then the decision would have been vulnerable to challenge by Tesco. Maybe, my lord, there really is nothing.
The benefit doesn't come from the development, it comes from the promise to use some of the income from the development in relation to the hospital site. It could have been a Birmingham store that could have provided the cross-subsidy.
Well, no, it couldn't, because, with respect, because the subsection, I do want to deal with this point, the subsection, that is 1 big A, includes its own limitation. The well-being benefits must arise in the local authority's area.
Of course.
And that isn't true. Your Lordship says, of course, that's not true of the Section 2 Local Government Act power from which this is derived. Under Section 2, as I'm hope to show your Lordship shortly, under Section 2 of the Local Government Act, the authority is able to look to well-being benefits beyond its area, but that is a limitation that is within the section. But yes, to come back, if I may, to your Lordship's sort of first point, the cross-subsidy arises from an offer that Tesco has made. It's in that respect, I suggest, indistinguishable in principle from the Royal Opera House case. I mean, the cross-subsidy from the offices, which, as I shall show you, Lordships, were separate. They're not linked by a bridge. They're physically separate. It's the administrative offices for the Opera House that are linked by the bridge. But in that case, the cross-subsidy from the offices to the Opera House refurbishment was only relevant as a planning consideration because the applicant had made it.
So going back to the wording,
yes.
Does it arise from the development?
Well, my lord, obviously we submit yes, but may I put it back to the statutory language? Is the development, redevelopment or improvement likely to contribute to the achievement of?
Surely those words just go to the standard of assurance you must have about a causal connection, as my lord's pointing out, between development and the object.
Yes, a causal connection within the meaning of those words.
But the council, sorry, I better press my button. The council would have got there anyway without the cross-subsidy, wouldn't they? I mean, given that there's a divided ownership, and they're obviously in competition in trade, and there is a veto, as it were, unless compulsory purchase powers are exercised, and if there wasn't this cross-subsidy, but nevertheless Wolverhampton needs a store of this kind close to the city centre, one would have thought one could get through the hoops of one capital A quite easily by just pointing to the benefits of doing this. So that the cross-subsidy is an additional layer on top of what is already there, isn't it?
That, my lord, yes. As I've already said, there is agreement that either scheme would bring its own well-being benefits.
Yes.
For example, catalytic effects, employment, and all those sorts of things. So the order could have been made on that basis, except that the council couldn't choose. It found that the two schemes, aside from the RHS benefits, which it took into account, obviously, aside from the RHS benefits, it found it couldn't choose between them. And I mean, I don't try and escape the very clear fact that this was described as the decisive advantage. Yes. I mean, that's the position. If they can't take it into account, then they're going to have to go back, obviously, and see how else they're going to distinguish between these two schemes.
But I in the light of what you've just said, yes, I do have difficulty in deciding what is the real issue here. Can you say they've improperly, or they would be improperly exercising their power if they have regard to an additional benefit, notwithstanding that there's quite enough legitimate benefit already? Or is the real objection to what they've done having regard to this in choosing between the two?
Well, as I understand it, it's the latter on the appellant's case, as I understand it. I mean, if perhaps may I suggest it doesn't. It's not. We wouldn't describe it as an additional benefit quite in those terms. Both schemes have their own merits. They have their own planning merits. Forget about well-being benefits. They both comply with planning policy to a greater or lesser extent, and that's all gone through with great care, if I may say so, in the report to Cabinet. The Council then, having decided that the acquisition would facilitate either scheme, and having established how the schemes performed in relation to the planning policies for the area, that's essentially subparagraph little 1 of paragraph 16 in Appendix A to the circular. It then moved on into little 2 in paragraph 16 of Appendix A to the circular, which is simply a reference to subsection 1 big A of section 226. And the Sainsbury's schemes well-being benefits are listed in the report and considered. The Tesco scheme's well-being benefits are listed in the report and considered, and they include, if you like, something extra, but certainly something that wasn't being offered by Sainsbury's. That is to cross-subsidise the development and redevelopment of the Royal Hospital site.
If you ask what one capital A is likely to have been about, it's pretty unlikely to have been about circumstances like the present, isn't it? What it's likely to have been about is the impact on the local area of the actual development, redevelopment or improvement. And what they wanted to see was that there was some beneficial wider impact of that. The idea that the parliamentary draftsman had in mind the present type of situation at all under 1A seems to me not easy to accept.
Well, it's certainly an unusual situation, but I certainly, with respect, wouldn't accept that if your lordship means that he wouldn't have had it in mind, therefore it can't come within the subsection, then obviously I wouldn't accept that. And
in the ordinary case, yeah. I mean, it's very difficult to think of a case where it would be relevant, because there would almost always be the other type of immediate impact on improvement of the environment, improvement of the employment prospects of people in the area, wages in the area, and so on.
Yes, there may be cases in which you wouldn't need to concern yourself with a consideration like this, possibly. But it isn't, I say it's going to be rare, this type of situation, but, you know, a cross-subsidy from one development project to another is not particularly rare, as one can see from the cases.
In a way, one of the attractions of your argument, without committing myself either way at the moment, is that it's on the table, it's in the open. Because sometimes one fears that things are happening behind the scenes and everybody knows, quiet whispers, that if they do this, something will happen. Now, I mean, obviously, people knew, it's absolutely plain, that Tesco have this relationship with the RHS side. And for the Cabinet to put this out of their minds probably was asking rather a lot. So what's done is to put it in the letter, and there it is, it's out in the open.
It is, I mean, obviously the decision was taken by officers on legal advice that the council could take it into account. And indeed, Sainsbury's own representations during the competition process on this subject, certainly as reported in the report, simply took issue with the outcome of the Tesco viability appraisal and said, actually, we think it's not unviable on its own terms, and therefore there's no need for that cross-subsidy. I could take your Lordships, I appreciate the time, but I could, if your Lordships wanted me to, just draw your Lordship's attention to that particular paragraph. It's in tab 20 of the core volume. At page 290, I mean, if your Lordship has said it was all in the open, starting at page 289, obviously, paragraph 610, the Royal Hospital site, all under the heading, page 288, economic, social and environmental well-being. Sorry, I'm rushing ahead. Page 290, paragraph 6.18, there's a lot of material about the Tesco appraisal, which the council had examined by independent consultants, and then Sainsbury's representation, 618, was that the Tesco appraisal is unrealistic, and that even if the cost of purchase is included, the scheme can produce a positive return to a developer. Their appraisal makes more optimistic assumptions, including lower development costs, higher sales rates and no social housing.
Can you go back to 616, which is talking about the subsidy equal to the loss? Now, the loss, presumably, is that this is costing more than they usually spend on a new store, and therefore, does that mean that in the early years their profits won't be as large as they normally are?
No, I don't think it does mean that. The loss it relates to the RHS, not the RSS.
Yeah, oh no, absolutely.
I'm sorry, I'm
it's not going to be a store,
apologies.
It's not going to be a store, the RHS.
It's not, the RHS isn't going to be a store.
Oh, yes, of course.
I mean, there was originally a proposal, actually, I think, from memory, for a store up, It's a refurbishment of Lisbon. It's got lots of flats in it, and the idea is a
So what's the loss then?
The loss is that the return from the development of the RHS falls significantly short of the costs of undertaking the development.
And therefore, it makes no kind of commercial sense at all for Tesco to do this, even if they do get the site, other than as an inducement. If they were acting commercially, they'd say it's still not worth the candle, even though we've got some nice profit coming in.
With respect, my lord, I'd say no, because they own the Royal Hospital site.
Yes.
They have previously put forward proposals on it that were non-compliant with policy, and therefore would have met, I don't believe there was an application which was determined, but it would have met, very likely, with a policy refusal of planning permission on policy grounds. So they've owned the site for quite some time, I think. They have now, or at least in the relatively recent past, decided we've got this bit of land, we're finding it terribly difficult to do something with it. If we want to make a profit on it, and therefore make it worthwhile us doing the development, we've got to propose something that's not in accordance with policy, and the council aren't going to have that. So we will make a planning application, which they did, and receive planning permission and an application for listed building consent, which enables them to undertake a development, which is financially unviable, but which they are prepared to undertake, providing they can cross-subsidise it from another development in the council's area.
How can they justify that to their shareholders unless they say we had to do this in order to get the profitable development?
I suppose that the answer, how can they justify it to their shareholders, is more for Mr. Kankowski than for me. But
if it's a loss-making scheme on the face of it, their only incentive for undertaking to do it must be that it'll be an inducement to get them the profit-making scheme. And if they didn't have to pay that price, there wouldn't be any commercial sense in their embarking on an unprofitable development which would mop up some of their profits, which could otherwise go to their shareholders.
Well, with respect, I can't really accept the word inducement because it obviously has connotations of illegality, potentially. But it's the real world, whether your lordship... I mean, obviously what your lordship says... let me put it this way. They wouldn't Tesco be contemplating spending money on an unviable scheme unless circumstances were such that was the only way of developing that site, which lies in their hands. I mean, no doubt, they tried to put the Royal Hospital site on the market. Given the policies that relate to that site, they wouldn't be offered very much money for it. I have no idea what they bought the site for, and I have no idea, obviously, what they could sell it for now. But this is, if I respectfully say so, this is the real world and how sites do get developed. Developers do develop sites with unviable development.
Don't we know, though, that in fact, if the present scheme falls through, the first thing Tesco is going to do is go back and challenge the stringency of the existing planning conditions and seek to get a more favourable development scheme on the Royal Hospital side. That, I think, appears in the papers, doesn't it?
I don't, my lord, with respect, think that appears in the papers, that we know that is what they will do. I mean, clearly they couldn't go back and just change...
It's discussed as a possibility.
Well, I mean, like any landowner who's refused planning permission or who finds, for whatever reason, that they are unable to implement a development scheme for a site. I mean, this is often an argument that one encounters at planning inquiries.
Well,
what are the consequences? I'm so sorry.
Paragraph 6.23 is Lord Mance's point. Tesco has indicated that if they're not selected, they would not be prepared to sell RHS, but would seek a more commercially attractive planning permission.
My lord.
That's exactly
Quite
the point that's being made.
Very well.
Obviously indicates just how profitable people are expecting the Raglan Street development to be, does it not?
Yes.
We'll adjourn until 2.